Hello, everybody. I am going to help you today by providing a free consultation on immigration waivers. We've been dealing in this area for 27 years, and to be honest with you, there's no easy way to present this. It's not something you're going to have a laugh over or that you're going to be highly entertained. And we were struggling with trying to figure out how to best present it, but we had a specific waiver that we conducted in the last couple of weeks that I said to myself, you know what, this would make great lecture material. So what I'm going to do is go through the elements of that waiver to explain to you what's involved in putting together a waiver for immigration fraud. Now, for those of you who don't know what the word waiver means overlook, forgive, move on with. And so this is for people who have willfully misrepresented something to the Immigration Department, the CIS, and are now seeking to be forgiven, for lack of a better word, for their past deeds and let back into the country. Now, we've dealt with all kinds of clients, from family members to CEOs, who have done something in the past or represented something to the immigration officials, and they didn't realize how important it was. And now all of a sudden they're trying to get in, they're investing a few $1,000,000, or they're marrying a U.S. citizen, and surprise, 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 somebody took it more seriously than the client did. That would be the Immigration Department. And now all of a sudden these people aren't able to be let in. Let's start with an important code section. INA is the Immigration and Nationality Act. Those are the immigration laws. And if you look under 212, you're going to find a list of items that, for lack of a better word, are no-no. INA 212. The subsection, for those of you who like that kind of thing, is A6, big C, small I. Any alien who, and an alien is anybody who's not a U.S. citizen or resident, by fraud or willfully misrepresenting a material fact, material means important, seeks to procure, which means get, or has sought to procure or has procured a visa, other documentation, or admission, and this is the one that's the most popular, by the way, into the United States or other benefit provided under this chapter is inadmissible. There are a number of areas that we get our law from: the INA, the Immigration and Nationality Act, the FAM, Foreign Affairs Manual, the CFR, which is the Code of Federal Regulations. So here it states the Foreign Affairs Manual directs consular officers applying this ground of admissibility to keep in mind, and then in quotes, the severe nature of the penalty that the alien incurs, lifetime exclusion, unless a waiver is obtainable, is possible. So the FAM, Foreign Affairs Manual, says that when imposing the penalty, the officer should keep in mind the Attorney General's quotation in a landmark opinion: shutting off the opportunity to come to the United States actually is a crushing deprivation to many prospective immigrants. Very often it destroys the hopes and aspirations of a lifetime, and it frequently operates not only against the individual immediately, but also bears heavily upon his family in and out of the United States. And that's from a case known as the matter of SNBC. What we're going to be dealing with today in this particular document that we've created is misrepresentation and fraud. Those are two grounds of inadmissibility. Inadmissibility means you can't get in, something that keeps you from getting in. So the standard for finding somebody inadmissible for misrepresentation: number one, there's been a misrepresentation by the applicant. Number two, the misrepresentation was willfully made. And three, the fact misrepresented is material. Material means important or critical. To find an alien inadmissible for fraud, the standard is as follows: there's been a misrepresentation by the applicant. The misrepresentation was willfully made. The fact misrepresented is material. Number four, the misrepresentation must have been made with the intent to deceive a consular or immigration officer. And number five, the representation must have been believed and acted upon by the officer. The Foreign Affairs Manual defines a misrepresentation like this: a misrepresentation is an assertion or manifestation not in accordance with the facts. Misrepresentation requires an affirmative act taken by the alien, and a misrepresentation can be made in various ways, including in an oral interview, in a written application, or by submitting evidence containing false information. And by the way, at least in my experiences of several thousand calls that I've received, it's usually in an oral misrepresentation because people feel they can get away with it the most. In determining whether a misrepresentation has been made, it's necessary to distinguish between misrepresentation of information and information that was merely concealed by the alien's silence. Silence, or the failure to volunteer information, does not in itself constitute a misrepresentation for the purposes of that 212 section. Now, the FAM, Foreign Affairs Manual, states that willfully is interpreted to mean knowingly and intentionally, as distinguished from accidentally, inadvertently, or in an honest belief that the facts were otherwise. In order to find the element of willfulness, in other words, that you wanted to do it, there must be determined that the alien was fully aware of the information that was sought and knowingly, intentionally, and deliberately made an untrue statement. For an alien to be inadmissible under that section, there must be clear, convincing, and unequivocal evidence that the alien made a willful misrepresentation. The misrepresentation must be made with a knowledge of its falsity. In contrast to a willful misrepresentation, a negligent is when you make a mistake, does not make you inadmissible. And that's from the Castaneda-Gonzalez case. The Department of State, which controls the embassies abroad, has developed the so-called 30-60-day rule. And be careful with this one, by the way. To assist in determining whether you've misrepresented your intentions to a consular or immigration officer. The rules applied such that when an alien who obtains a visa as a non-immigrant applies to all of a sudden become an immigrant, that's called adjustment of status, to a permanent resident, fails to maintain their non-immigrant status within 30 days of entry. For example, we have a lot of people who turn around and decide that they're going to enter the United States, marry a U.S. citizen, and remain here. That's not allowable. Let's say you came to San Diego on vacation. You met somebody, and out of the blue that you didn't know before, and then you're crazy about each other, great chemistry, you decide to get married. That's one thing. But if you were communicating, had a relationship, and then you decide to fly in to marry them and stay here, that's not allowable. You actually have to apply for a fiancé, which is called a K-1 visa, or a green card from outside the country, and it takes you about 8 months to get it. But a lot of people try to enter illegally. It becomes a big problem. Now, the government will give you, a 30, 60-day benefit of the doubt. You have the opportunity of providing evidence that you didn't enter with a false intent if it's within such a time period. But also be careful. These people are very well trained. I mean, very, very well trained. And, a lot of people have been told by various immigration lawyers, oh, go in there, wait 60 days, then do this, or wait 30 days. Don't do it, because you cannot answer all of the questions correctly. There are things that you do and don't do when you're in a certain position. And when you're asked these questions, you won't be able to overcome them. And I've seen this time and time again. A lot of people think they can get away with this, and I'm all for taking risks, but not with the law. With entrepreneurship is where I take my risks. But in this area, you want to be straightforward, because surprisingly for most of you watching this, you can get away with a lot more if you're honest to them than if you aren't. Another section, the Attorney General may, in the discretion of the Attorney General, waive, which means forgive, the clause subsection I of subsection A 6C of this section in the case of an immigrant who is the spouse, husband or wife, son or daughter, of a U.S. citizen or of an alien lawfully admitted into permanent residence if it is established to the satisfaction of the Attorney General that the refusal of admission to the U.S. of such immigrant alien would result in extreme hardship to the citizen or lawfully resident spouse or parent, not child, spouse or parent of that alien. Now, that's what's called the extreme hardship waiver, and I'm sure you've heard about it. Evidence of extreme hardship includes emotional difficulties of family separation, financial dependence, serious illness, and other forms. And trust me, there are many other forms that can be used, because a lot of people have gone to various lawyers who've said, oh, why don't you see a psychologist and tell him how depressed you are, or tell her how depressed you are. Of course you're going to be depressed. But if it's a standard depression of separation and nothing beyond that, it doesn't qualify under extreme. And in terms of financial hardships, not having two incomes over one, well, guess what? Everybody who's single only has one income. So that doesn't help you. So they're looking for extreme hardship. Let's say somebody has a 10-year bar and has been living outside, their spouse has been living outside the country for 10 years. And the U.S. citizen only gets 4 weeks off a year and spends those 4 weeks with their spouse, and as a result can't even see their own parents who live somewhere else in the country because they're trying to keep that marriage together, and the person is getting old. Let's say the person happens to be 55. In my opinion, such a case would make sense. I mean, what are you supposed to do? Wait until you die? The person has spent their 10 years outside the country, and they've done everything that they had to do. They made a mistake. They were young at the time, didn't know any better. In my understanding and belief, such a case would make sense. So it doesn't have to meet the black and white, and certainly don't listen to the advice of just going to a psychologist. Again, the government knows what they're doing, and these officers are very well trained. Now, evidence of extreme hardship includes the emotional difficulties of family separation, financial dependence, serious illness, and other forms, but also includes present and foreseeable future hardship. And that was from a case called the matter of Shaughnessy, BIA case, Board of Immigration Appeals, 1968. The BIA has held that the common consequences of deportation, separation from family, or financial hardship do not, as I stated just now, without more constitute extreme hardship. The hardship to offspring who remain in the U.S. after the parent's deportation is a relevant consideration, although that alone is not extreme hardship. Economic considerations alone are not enough. A family member's financial status without the applicant is a relative consideration. The case law suggests that while demonstrating one factor is not enough to meet the requirements, a combination of the above factors could be enough to establish extreme hardship. In Palmer versus INS, the court found that no extreme hardship to adult children who are self-sufficient and did not depend financially on the alien. In Caramonte versus INS, the adult son's testimony that he would be sad if his father was deported was just not enough. Of course he'd be sad. The factors to be used in determining whether somebody has established extreme hardship include, but are not limited to the following: the presence of lawful permanent resident or U.S. citizen family ties in this country, the qualifying relatives' family ties outside the United States, the conditions in the country to which the qualifying relative would relocate, and the extent of the person's ties to such countries, the financial impact of departure from the country, and significant conditions of health, particularly when tied to the unavailability of suitable medical care in the country. In a recent decision issued by the Administrative Appeals Office, the alien was a native and citizen of Lebanon, and that person was seeking a waiver of inadmissibility under 212A9B and lowercase 5, which is a B, for unlawful presence, and INA section 212, small I, for fraud or misrepresentation in connection with a previous fiancé visa, which is also called a K-1 application. The applicant admitted to an ICE officer that he had entered the U.S. on a K-1 visa on September 22nd of 1999, but had no intention of marrying the woman who filed the petition. Well, what does that tell you? Because when you're the beneficiary, the person who benefits from a K-1 visa, fiancé visa, the whole idea behind you entering on a fiancé visa is you marrying that person who is your fiancé. So this person stated, I have no intention of marrying her. He later married a U.S. citizen and had a U.S. citizen child. And he was later ordered removed from the country and granted voluntary departure. He departed the United States in 2006, having accrued more than 6 years of unlawful presence in this country, and then sought a waiver of inadmissibility to re-enter as a spouse of a U.S. citizen. The waiver application was denied. But the AAO overturned the decision. The AAO stated that extreme hardship to the U.S. citizen had been proven. The wife and child visited the applicant in Lebanon in July of 2006, days before the armed conflict between Israel and Hezbollah began. They suffered through bombings. They were eventually evacuated to a camp in Cyprus. The wife and child returned to the U.S., where the wife began to suffer emotional hardship, as evidenced by the diagnosis by a psychologist who had only seen the wife on one occasion, but diagnosed her with major depression as well as symptoms of panic attack with anxiety disorder. The applicant's wife was in danger of recurrent and more serious episodes of depression because her mother also suffered from depression. So this was, a realistic case. The observations by family and friends corroborated the psychologist's testimony. She also had extreme hardship with respect to her 10-month-old son. He suffered from asthma. He frequently needed medical treatment, including several hospitalizations. Medication would not be available in Lebanon. The pediatrician's statement stated that it's in the child's best interest to have both parents there, as he frequently required all-night surveillance and had more than one late-night trip to the emergency room. Based on this, the AAO found that continued separation from the applicant would constitute extreme hardship on the wife because her own emotional state, her reaction to her son's medical problems, combined to establish that she would suffer extreme hardship if she continues to care for the child without the applicant. The AAO also found that she'd suffer extreme hardship if she were to locate to Lebanon. The son would require medical treatment in Lebanon. His medication is not available in Lebanon. The family would not be able to afford health care. Country conditions were severe because of the devastation caused by the bombing in Lebanon. The fact that more than a quarter of Lebanon's population lives below the poverty level, with the unemployment rate at about 25%, and the most recent State Department's travel warning advising strongly that U.S. citizens not travel to Lebanon. So, as you see, they are fair in analyzing, the various aspects of a case, so that if there is extreme hardship, they will overlook a lot. Once the statutory statutes, laws, requirements have been met for a waiver, the CIS, the Immigration Department, still has the discretion, they can decide which way, to decide whether or not to give the waiver, even if you meet all the requirements. Establishing extreme hardship does not make you entitled to relief, but it's only one factor to be considered. Some of these factors include evidence of rehabilitation, the applicant's family ties, whether the applicant has a criminal history, and an applicant's immigration history, including things like unlawful entry, deportation, and removal. So, in this case, where we had the citizen of Lebanon seeking a waiver of inadmissibility, the AAO also discussed the balancing of the equities are things in your favor, and the discretionary factors that they can think about one way or the other. And it found, in its discretion, that the applicant had demonstrated the equities in the U.S. outweighed the adverse or bad factors as delineated in the case called Mendez-Morales and merited the waiver. It also found the favorable factors: extended family ties in the U.S., extreme hardship to the U.S. citizen wife, the health problems, etc., etc. So again, they're going to give you a fair crack at it if you explain everything that's required. And if you don't meet one requirement, it doesn't mean that your case is thrown out the window. The government will fairly look at the various factors and how they apply. But please, there are many lawyers out there who say, go see a psychologist, get a report. Of course you're going to be sad. Of course you're going to be depressed. But if you don't have a history of depression and various other factors that coincide, it's really not going to be enough. It's actually going to be a waste of your money because when you're getting a private consult, it's not going to be paid by insurance. It's going to be paid by you. At the end of the day, it's going to be the kind of situation where if truly you can prove that you merit a waiver and you have the evidence and you have factors that are favorable to you, you will get one if, of course, the lawyer knows how to write a good waiver. And if not, it's a difficult position. And the best advice I can give you after seeing this now going on for 27 years is these officers aren't trying to pull one past them. Especially what surprises me is we have clients who have a lot of money, can afford a visa, don't bother getting one because they think they can get away with something on a B1 or a B2. We see this all the time, or hear of it all the time. It doesn't make sense. But if you need an immigration waiver, now you understand some of the factors that are required in a fraud waiver. And the best thing I can say to you is I hope that you never need one. Have fun in America. It's a great country. I wish you all the best.